Morning, I'm sorry.
You're going to reserve 5 minutes?
Yes, Your Honor.
Okay, go ahead, please.
My name is Joe Camino. I represent the appellant in this case, Mr. Bryant Hurt. We are here after Mr. Hurt was convicted of a count 2 misdemeanor assault in circuit court here in Hillsborough County. We are appealing the denial of his motion for judgment of acquittal as it relates to the assault count.
What's the difference between an attempt battery and an assault? The technical legal difference between an attempted battery and an assault?
I've never had an attempted battery, but...
Well, you're going to have to, I mean, this is really what this case is all about. Is it an attempted battery or is it an assault? And if so, what's the difference?
I would submit that the battery would require the intent for him to intentionally strike the victim in the case and attempt to do so, not necessarily that the person saw it.
Isn't a battery like a swing and a miss? And whether or not the victim saw it or was in fear is not relevant?
Correct.
Whereas an assault requires this putting in fear, right? Got to see it, putting in fear, right?
Yes, Your Honor.
Okay. So take it from there, because that's what this case is about to me.
Okay. Well, the defendant in this case, the appellant, was acquitted of the battery charge, and specifically with respect to the assault charge, the first element is that the state would have had to have proven beyond a reasonable doubt that he did some unlawful act intentionally towards the victim in the case. And I would submit that the record has no evidence that the appellant, Mr. Hurt, did any act in this case, unlawful or intentional, that would have caused the victim in the case to have a fear that violence was imminent.
There's a little problem here because we don't have the entire record. This is a de novo review, denial of a JOA, and the burden is on you to provide us with a complete record or the pertinent parts of the record for meaningful appellate review. Now, we don't have the testimony of the firefighter Canister. We don't have the testimony of Deputy Collins or any closing arguments. What we do know from the record is your client was Mirandized and admitted to the assault by saying, yeah, I swung at him, but I didn't hit him. And I think we can tell from the victim's testimony was he was hit by someone with some hard object and did suffer some type of injury, but the jury acquitted your client on that. But then when he was asked by the prosecutor on 233 of the record, at the time he came at you the second time, were you in fear that he would strike you again? The victim said, yeah, I kind of just spun around to get away. So is not that evidence of fear? He had already been hit in the head, and then someone's coming at him again, and he's expressed under oath, yeah, I was in fear.
Well, Judge, I would submit that the pertinent testimony with respect to the second action in the case, which is what Your Honor is addressing, when he was asked on page 89 of the record by the prosecutor, Mr. Ceballos, he asked, did he do anything else to you? And he said, I'm not sure, I was just in shock. And then he was also asked, what was he doing? And the victim testified he was walking towards me with an attempt of something. But I would submit to the court that the appellant was acquitted of the initial action. And at the trial level, we made clear during our motion for judgment of acquittal that there were two separate actions, and the second action was going to be relevant to the assault charge. And so what that action is what we're here for today. What was it that the defendant or the appellant did in this case that would have rose to the level of the assault?
Well, I can understand the acquittal on the battery because he did testify, I didn't see who hit me. It's a peripheral type of thing. He thought it was a firefighter throwing a hose over his shoulder. So I can kind of understand that. But still, he's asked the second time he came at you, and this is he being the defendant, were you in fear that he would strike you? He said, yeah. So looking at the evidence in the light most favorable to the state and reconciling all conflicts in favor of the state at the time of the JOA, how did the judge err?
The Swift case, that's a Second District Court of Appeals case, I think is the case that addresses this particular issue, Judge. That's at 973 Southern 2nd, 1196. It's a Second District Court of Appeals case from 2008. It addresses this very issue, the victim's perceived fear. In this particular case, the Swift case, the victim was a law enforcement officer and was standing at the rear of a vehicle where he was trying to pull out the occupants who were not cooperating with him. The driver of the vehicle put the car in reverse and started heading directly towards the law enforcement officer. The officer testified that he was afraid, based on the action, that violence was imminent. And the Second District Court of Appeals said, well, it's not relevant on the issue of the elements as what the victim's perceived fear was. It is what was the defendant, or in that case, and in this case, the appellant's actions. Because that is the number one element of assault, is what is the unlawful intentional act that the appellant or the defendant committed. In this case, there is nothing. Just because a victim or any one of us perceive a threat doesn't make it an assault. The defendant or the appellant in this case would have had to have done something unlawful, something intentional to make that threat. In this case, the only thing that Mr. Feldkamp, the victim in the case, testified to was he was hit, and then he saw the defendant, Mr. Hurt, and he saw, at one point he said he walked towards him. At another point he said that he was 1 foot away from him. And I would point out that the main reason that we requested oral argument in this case is because the state, in their brief, alleged that the record reflected that the appellant ran towards the victim, which is completely not in the record at all. It's inaccurate, and just a mere walking or being present next to a victim is not an action that would be an assault, regardless of what the victim may perceive.
Well, I appreciate your bifurcating these into two specific acts, but the judge is charged with looking at the totality of the circumstances, and this was probably a matter of seconds before each incident, as you've termed him. He's been hit in the head, doesn't know by who, and then he sees his neighbor, Mr. Hurt, coming at him.
Well, did he say he's coming at me, or and then at another point he says he walked towards me, and another point he just says he's standing next to me. Now, that I would submit goes to whether or not it's substantial, competent evidence to sustain a conviction. But Judge, as the Swift case states, it's not the perceived threat by the victim. It's what is the action of the accused. And in this case, there is no case that the state can cite or that I could cite that says just walking towards a person, as he said on page 89 of his transcript, is an assault. There was no threats. There was no verbal threats. It's not even walking in an aggressive manner. He didn't even describe that. He didn't raise his hands. He didn't look upset, the appellant. There is nothing in this record that shows that that's what the defendant did.
Well, it appears that Deputy Collins was there when it happened because he was able to restrain Mr. Hurt from maybe even hitting the victim again. And we don't have Deputy Collins' testimony to explain or characterize what the defendant looked like, how he approached, what manner he approached the victim. We don't have that.
And Judge, I would submit to the court that I would be happy to supplement the record, but there is nothing in any other witness's testimony that describes anything, and there's nothing mentioned by the state in our judgment of acquittal arguments that any other witness saw any action by the defendant that would have caused there to be any perceived threat or any threat by the appellant in this case. It's the testimony was, and really what another witness says in an assault case isn't going to be necessarily relevant as to whether there was an assault, because it goes back to what are the actions that the victims observed and whether or not those actions were reasonable in creating a well-founded fear of imminent violence.
Well, you know, as I think, I mean, it's really clear from the transcript on direct examination, and we've kind of touched on it already, but basically the victim says at the time he came at you a second time, were you in fear that he'd strike you again? Answer, yeah, I kind of spun around to get away. What more do you need?
I'm sorry, what do I need?
What more do you need?
Oh, well, if you look at the totality of his testimony, I think that he says, in addition to that, the prosecutor asked him again. He said, did he do anything else to you? And he says, I'm not sure, I was in shock. He also asked him to describe what the appellant did when he observed him, and he says he was walking towards me.
He was walking towards me with an attempt of something.
Correct.
Or his exact statement.
Right.
Something happened that caused him to spun around and want to get away, and this is a second incident. Isn't this just a classic jury question?
I would submit that
I mean, people don't just, you're in an encounter with somebody. There's already been one exchange. He's coming at him a second time. He spun around to get away.
But is that action just me walking towards someone, or this person walking?
But it's not just. It's you're taking it in the abstract. There's a history here of something else happened before this, and then he comes at him. I'm just going on the testimony and what the presiding judge heard. He is walking toward me with an attempt of something. He's doing something. And again, as Judge Sleet pointed out, it's kind of a scant record, but what we do know is it's a second incident. He's coming at him with an attempt at something. He was in fear. He says he's in fear he would be struck, and he spun around to get away. I'm struggling.
I understand.
Actually, I'm not struggling.
I understand,
And the trial judge really, at this moment of truth in the motion for judgment of acquittal, as is in the often quoted position in Lynch versus State, it's the trial judge's proper task to review the evidence to determine the presence or absence of competent evidence from which the jury could infer guilt to the exclusion of all other inferences. That view of the evidence must be taken in the light most favorable to the state. So we have these statements, which I read from the transcript and which we've talked about. I don't know what else a trial judge is supposed to do. This clearly is, as Judge Black says, a question for the jury to resolve, and they did.
well, I would submit that I understand what you're saying,
The
yes.
officer's present, right, when it happens.
There's numerous firemen
lot-
present.
Yeah, I mean, it would, since it's your burden, I would love to see somebody's transcript who was there saying, that didn't happen like that. That we were all just standing there. But in the absence of that, this is what we're left with. A jury question.
And this is the relevant testimony as to what happened, and anything else would have been included and could have been included by the state in this case.
Mr. Camino, I remember you from when I was a trial judge, and you're an honest fellow, but we need sworn testimony, not just your word that this is all there is. We're here looking at paper, looking at sworn testimony. This is all we have to go on. You haven't persuaded me that it's not a jury question. Maybe you've persuaded them. I don't think so. But if that's all there is, I just don't see it.
Yes, Your Honor. Well, if there's any other questions, I'd be happy to ask or answer them now. I appreciate the
We're going to
support.
gang up on him, too. Don't worry about it.
Okay.
May it please the court, Jason Miller for the appellee. And it's the position of the appellee, Your Honors, that this court should affirm the judgment of the lower court for all the reasons that were voiced on the appellant's portion of his oral argument, initial arguments. Essentially, there are two acts.
Yes, but you don't get the benefit of that draft because, we obviously are pressing him on his point, and
Yes,
so
sir.
the point I would have to press you on is that there's almost no evidence here at all of an assault. I mean, we have the barest and the scantest of testimony from which a leap has to be made that maybe this was an assault.
Well,
So walk me through what really you have here.
Sure. We have the testimony of the victim in this case, who indicates that he recalled and testified to two distinct acts or bifurcated instances of what he described as an attack. The first one being something in the corner of his eye, that he saw something coming at him. He raised his hand to it. It was struck both in the hand and also in the head. There's testimony of that. He did actually see the person who it was. He just didn't at the time perceive the identity of the person. Shortly thereafter, he did have the perception of who it was. So that could have been a battery. That one actually fell to not guilty. Then there's testimony which he repeats multiple times, that same person then comes at him, walks towards him.
Is it true that there was law enforcement there and fire rescue there as well? So how could he be in fear? Were you surrounded by law enforcement?
And I'm not clear he knew it was the same person, because he says something hit him, but he doesn't know from where, what, or how. He thought it was a hose that the firemen were swinging.
He thought it was a
So
hose.
there's no evidence to suggest that he knows it's the same person.
After he describes that, he goes on later in the record to indicate that it was a reflective vest that he saw, and that same person is the person who then comes at him, and a law enforcement officer, perceiving there to be an issue, steps in between them. So there's additional evidence indicating that his perception is accurate, that there is something going on for which law enforcement, or I'm sorry, a firefighter, in fact, firefighter Canister has to step in between them.
In order to get past JOA, does the fear have to be, is it an objective fear or a subjective fear?
I believe it's a reasonable fear. So
So if someone's walking towards him, and then the question is, did law enforcement stop him? And he says, yes, law enforcement stopped him and asked him who he was. So now he's talking to law enforcement. Is it reasonable that he's in fear with law enforcement in between him and the individual who's advancing?
I think it is, specifically for your question on the initial oral argument, because there's additional factors. It's not just that somebody's walking at him and law enforcement stops to say, who are you? There's the fact that he was just what he describes as being clubbed in the head with a blunt object.
Yeah, but this is not just two people having a fight at this point. This is some sort of incident followed by the intervention of law enforcement.
Yes.
So again, if he's walking over and you got a police officer between the two of them, I'm not sure that that's reasonable.
Well,
It's a reasonable fear.
But the facts of the case aren't limited just to the fact that there's a person in between a law enforcement officer or a firefighter. I believe it was Officer Canister, but I may be mistaken. But nonetheless, either an officer or a firefighter in between a person, and that the person whose perception that we're inquiring about has testified that just previous to that he was struck in the head by this other person that he's now being separated from. So that's a possibility, or that adds to the evidence that his perception is reasonable. Perception of being attacked a second time from his testimony that he indicates he was afraid of being struck again at 89.8, and he testifies to it again at 93 that he was struck in his hand and in his head, and he was perceiving that fear. He testifies to it a second time.
But the victim said that he thought a fireman accidentally hit me.
Yes, he does testify to that, indicating that's his initial perception at the time he's being hit. And then immediately thereafter, he sees that person isn't actually a fireman. It's actually his neighbor, the appellant in this case.
Yeah, I didn't actually see any, he says. I just saw out of the glimpse of my eye some kind of safety suit which looked like a fireman. So he reiterates that. He's thinking it's a fireman, and obviously the perpetrator in this case was not a fireman.
That's correct, but he was wearing some type of safety or reflective vest to give that appearance, and after that perception, after that testimony, it goes on to indicate that it was his, at 87:20, the victim realizes that his neighbor was hitting me, was hitting me with something, whatever it was. He says that on I believe it's 87:20.
Did the state introduce a post-Miranda admission?
Because of the record, Your Honor, I didn't see that in the record here, so I can't answer that question. But there was testimony what is in the record is the probable cause affidavit, which I did read, which indicates a statement about the assault. He swung at him, or he made movements towards him in that regard. So it's likely that that was part of some testimony. And the other question that I would like to address is this first act of the blunt object hitting him goes to, in fact, the ability to carry out the threat or the reasonableness of the fear. The difference between the assault, attempted battery, and an assault, appellant is correct when he cites to Shaw, indicating that the inquiry is to the intent of the defendant. And in this case, the perception testimony that we have just goes to reinforce essentially what the police officer the officer stepped in between them, reinforcing that testimony. So I think all three elements of assault were properly at least before the judge, and that's really all we have to get to, or before the jury, is were they competent to be testifying? And since there are multiple statements of each of the three elements, I would ask the court to affirm based on all of the pieces of evidence and best light for the state.
Okay.
Thank you, Your Honor.
Thank you. You have 5 minutes if you want them.
Just want to make sure that nobody has any questions for me. It's taken me a few years to be able to get Judge Sleet down here from Lakeland or Myers. So.
It's nice to be in Tampa.
But seriously, with respect to Judge Black, to your main concern, I think, with the case, it was important for us to try to bifurcate, even though this did happen within a couple of seconds, very fast, because there was no testimony or any evidence that the defendant actually was the one who committed the initial act. Mm-hmm. In fact, all the evidence was to the contrary. So our main argument at the JOA and also to this court is that we would submit that the actions that he took, the defendant, appellant Mr. Hurt, were insufficient for an assault because there really were no actions that were proven that he committed other than being present and walking towards the victim with the attempt of something. So that is why we would submit that this review, there would be a lack of evidence as to any intent with respect to the holding in the Swift case, and also because of the lack of any testimony and evidence of any actions that Mr. Hurt did. Thank you for your time.
Thank you.
Thank you.
Interesting case, well argued. It's a close